Yeah, Naveen, so we can start.
Okay. Good evening, everyone. We've again got an excellent panel today. And the master of ceremony today and the host is going to be Venkat. Venkat is a CA by qualification and an entrepreneur himself. So he's the founder of My CFO and Practice Advisory. And he has been pretty much instrumental in helping small-time business owners, two large businesses, on turning around their businesses and giving them all F&A kind of advice. And he also helps a lot of CFOs in their scale-up strategy. So I think this is an apt time where we've got an interesting panel. And I would now welcome Venkat to take it on and take it further from here. Over to you, Venkat.
Thank you so much, Naveen. Thank you, Team TiE Mumbai, for this wonderful opportunity. First up, wherever you are, I hope all of you are staying safe, staying indoors, staying healthy. It's a very pleasant duty for me to introduce the very distinguished panel today. I'd like to start with Harshita Srivastava. Harshita is a partner with Nishit Desai Associates. She's a partner responsible for startups and venture capital investments at the firm. Harshita, interestingly, used to work for Nexus Venture Partner. So she's got a very unique perspective here, both from an investor angle and obviously now in her capacity as a corporate lawyer. Welcome, Harshita. I'd like to next introduce Aprajit, who is a partner with DSK Legal. Aprajit is largely focused on corporate commercial, on M&A work, and on private equity. He's an award-winning lawyer, and he's received several recognitions from Chambers Asia, Global Legal 500, and so on. Aprajit sits on the boards of several companies, but the one I thought was really interesting is that he's on the board of SightLife, which is an NGO that is dedicated to eliminating corneal blindness. Welcome, Aprajit. I'd like to now introduce Ramesh Vaidyanathan, who is the founder and managing partner of Advaya Legal. Ramesh, again, has been a partner in private practice in the past before he decided to take on a corporate role. He has been the general counsel for Mumbai International Airport, and he was the group counsel for GVK Group. Ramesh's area of interests are mergers and amalgamations, joint ventures, project financing, infrastructure, aviation, and franchising. He currently is an office bearer of the Asia Pacific Regional Forum of the International Bar Association. Welcome, Ramesh.
Thank you.
Last but not the least, my good friend Aaron Solomon, who is currently the managing partner of Solomon & Co., one of the oldest law firms in the country. Aaron's special area of focus is joint ventures, exchange control regulations, competition law. Among his several other positions that he holds, he is also an advisory member of the China East Asia International Trade Dispute Settlement Advisory Committee. Incidentally, Aaron Solomon is an examination topper. He held the #1 rank in the All India Solicitors exam in 1996. Welcome, Aaron.
Thank you.
Right. So a quick introduction to the flow of the program today. What we'll be doing is I'm going to invite each of our panelists to probably share their opening remarks about maybe about 3 to 4 minutes each. So that'll probably take us about 15 odd minutes. This session is really about all of you, the participants, and thank you so much for writing in with your questions. We received about 200 questions. Needless to say, it's not going to be possible for us to cover all 200 questions. What I've done is to take the liberty of reading about 8 to 10 questions. That will maybe cover about 65%, I think, of the queries that you kind of wrote in with. Obviously, if there is anything interesting, and you can please feel free to continue raising your questions on chat mode. That's open to you. We will have the Q&A, which will be moderated by me for about 60 odd minutes, post which we'll still have about 10 to 12 minutes to take any additional questions that you might have during the course of this webinar. The last 5 minutes, I'll leave it to the panelists to possibly provide their concluding remarks. So to kick off, there are several clauses and agreements that as entrepreneurs we happily sign off. I think very, very few of us have got the ability and the patience, the willingness to kind of read through maybe 30, 40, 50, 60 pages of legal agreements. We leave it to our friends like Harshita and Aparajit and Aaron and Ramesh to kind of do all the hard work. But we're suddenly now discovering new words like a new French word called force majeure, which probably 4 weeks back none of us would have been aware of, but it's now suddenly in vogue and very much in fashion. Everybody wants to know how they can be either adversely impacted by it or how they can use it to their advantage. So this session, more than a legal session, I would like to call it a commercial session. This is really about cash flow protection. It's about being able to protect relationships. It's about business continuity, and how do the legal fallouts arising out of COVID impact the entrepreneur's ability to deal with our business and to keep it going is really going to be the focus of this session. So with those few words, if I can please start with Harshita, and if I can request the panelists to really kind of talk about what are the themes that you're hearing about from your clients. What are the top concerns on their minds? And now that we're kind of seeing the issues kind of pan out over the last 3 to 4 weeks, are you also able to give us a high-level view of what are the kind of solutions that you're recommending to the clients, and what kind of decisions are your clients beginning to take with regard to dealing with the legal fallout? Over to you, Harshita.
Thank you, Venkat. Thank you for the great introduction to all of us. I would start off by saying that, of course, a lot has changed, and in the last month or so, and it wouldn't be exaggerating if I mentioned that in the most literal sense, the world probably has stopped for a lot of us as a result of some of the preventive measures which have been taken by government bodies across the globe. To control the pandemic, I believe small businesses, startups, and entrepreneurs are essentially, they have come out to be essentially one of the most vulnerable groups that have been directly affected, by these measures. Whether it is the preventive measures or the general chaos around the situation, I think COVID-19 has caused extreme, disruption both socially as well as economically for all of us here at least. Now, diving directly into the topic, which is what are the kind of questions that I've been receiving from clients in the, who are also, and specifically entrepreneurs dealing with the COVID-19 situation. I think 4 broad heads, if I can quickly point out. One is in terms of the supply chain breakdown, and how are they going to help, what are the recourses that they have under their supplier customer contracts, and we can I'll deal with it in terms of the force majeure that Venkat was mentioning, and whether you have such clauses, whether you don't have a contract at all, etc. Second bit would be the employees, which is whether to terminate, whether to pay them, whether not to pay them. What do you do with the new hires that you have agreed to onboard during this period and the lockdown happened, whether you really are in a position financially to onboard new talent, or how do you deal with that situation? The third has been around rents, which is whether you're in a landlord position or a tenant position. I would assume a large part of this audience would be in the latter position, where you are occupying a premise on a leave and license basis. What do you do? Can you seek a waiver of the rents that you are paying, whether your contracts allow you to do that, and if your landlords aren't agreeing, do you have a legal recourse against them? And I think the fourth one that I have been getting a lot of queries on is essentially compliance relaxations. So is there something that the government is doing to ease the compliances which are which are required to be done by companies under Companies Act, under foreign exchange control laws, etc. So I think broadly, to deal with these 4 situations, Venkat, do I need to deal with these 4 situations right now, or should we take it up in the course of the session?
I think we'll probably pick it up during the course of the session, but thank you for providing your overview, Harshita. If I can please come across to you, Aparajit, is your experience similar to Harshita? Are these kind of the 4 buckets in which most of the client issues seem to be falling into, or do you see some other areas as well?
Thank you, Venkat. Thank you, Harshita. I think I would echo what Harshita's said, and primarily the issues that corporates or startups or entrepreneurs are facing today are more or less on the same lines. Mostly what we have been dealing with, the queries which started from around mid-March, around the 3rd week of March, have been primarily in relation to manufacturing facilities and continuing with manufacturing operations. situation was different, a little bit different prior to 20th of April, as we all know. Things have been relaxed a bit post 20th of April, then the advisory and the queries around that. Employees have been a big chunk, and specifically pay to employees and the, the uncertainties around it, as well as the variety of notifications that have been issued all at the central government level as well as the state government level. Insurance, disruption of business and insurance claims around that has been a piece also that we've been advising clients on. Rest, I think Harshita covered leases, financing moratorium, what the relaxation, that RBI has proposed and the nuances around it. I think broadly it's been around manufacturing, supply, employees, insurance, property, lease, and financing. I would say from a business standpoint. And as you said, of course, we can deep dive into each one of these items as we progress in the discussions. For now, I would pass it back to you.
Got it. Thank you, Aparajit. Aaron, Ramesh, if I can come over to you, and once again, are there any other categories of issues that you're hearing from clients? But if I can please request you to maybe focus your comments a little bit more on, are you beginning to see potential solutions, or at least trends in solutions that clients are choosing to adopt to face some of these issues? And are you able to kind of give us an overview of what these solutions really are?
So thanks for having me on this panel, and thanks for joining in large numbers. I think with the number of attendees, it says a lot in terms of our people and a nation in terms of continued learning, even in the course of this lockdown. And Venkat, to respond to your question, I would just maybe back up to, I would say, the beginning of March. I think most of our clients were confused on what should I be doing to tackle this issue. Maybe now it's evolved to a phase where most businesses have an idea of what they do want to do. They do want to defer certain payments. They do want to defer certain costs. They do want to renegotiate certain contracts. So I think most business owners do have clarity on how they're going to tackle the current challenge. I see it possibly evolving to a third stage, which we are seeing early days of, where most businesses are now beginning to consider what do we do after we come out of this lockdown? What is the path forward? And that's exactly, I think, what Venkat touched upon. And I think again, we'll be talking about multiple different things. Clearly, in large numbers, most clients and businesses have opted for the moratorium offered by the Reserve Bank of India. And many of the relaxations coming out of the Ministry of Finance are all being opted for as a matter of course. And I think what is also important to keep in mind is many Indian businesses are looking at this as an opportunity. They realize they're going to be coming out in a new world, in a new economic environment, and they're going to have to do things differently. So one part of our discussion would be in terms of to deal with the present and the past, and how do we re-engineer it to meet the challenges, of the current time and going ahead. But two, what is also very important is the way forward, and how do we re-engineer and rework our business and re-look at our contracts and commitments, so we are best placed to take best advantage of and grow in a new market condition. I think it's very important to keep in mind that some of the world's biggest manufacturing companies grew after World War II. And while there's certainly distress and stress assets and companies and businesses in trouble, it is also possibly there will come a time where there's opportunity, and the companies who handle it well, financially, legally, and most importantly from a business perspective, there's definitely opportunity to succeed.
Got it. Thank you, Aaron. Ramesh?
Yeah, thanks, Venkat. I think my thoughts are similar to what Harshita mentioned in terms of the the kind of questions that we are fielding from clients. And you would typically expect a force majeure clause, as always lawyers call it, like a boilerplate clause. And, you would probably not spend a lot of time negotiating it. So I think one immediate, if you say one big learning or course correction as far as this is concerned, is the focus on
good contract. I think that's, if you ask me, this tremendous visibility on the need to build good contracts by getting expert inputs. So I think that's, if you ask me, that's one thing that has kind of become highlighted. In terms of what we're telling clients, to some of the questions that are some of the issues that have come up is essentially to communicate more. Essentially, be it in terms of employees, be it landlords, be it whoever the counterparty may be, or supplier, vendor, without jumping into a force majeure notice or a termination notice, or really an email suggesting pay cuts. Are you able to kind of drill down the seriousness of the issue and a sense of partnership through effective communication? That's something that we're saying. And secondly, that communication being right, something which doesn't spread panic, but at the same time, if it's something that that's let's say notifying a landlord or notifying an employee, you're making sure that you've checked with your experts, and you're not confusing your financial constraint with other things like force majeure. So I would say, in terms of, I don't want to repeat what has already been mentioned, but in terms of the solutions, they're not really emerging as of now, but the expectation is that with communication, with a bit of patience, and continuing to engage with vendors and counterparties, I think that's a key step that we are telling clients. And the reason why it's probably too early to look at solutions is there's been a lot of inconsistency in some of the notifications that have come out. So there's a bit of speculation on who's covered, who's not covered. So it may be too soon to to really plan any remedial action based on the inputs that we currently have. So mitigate the risk and stay where you are, and then keep plugging on. So that's the kind of advice that we've been giving clients. Thank you.
Thank you, Ramesh. So if I could probably kind of kick off the set of questions that I had, starting with you, Ramesh. So you kind of briefly alluded to force majeure. So for the benefit of the participants, are you able to give us a quick summary of what exactly does this clause mean? And are you able to give us some ideas in terms of whether it's seems to be a lot of hope in corporate India that this clause will kind of come to their rescue when it comes to possibly, if I may use the word, flexibility in terms of getting out of certain types of contracts. So specifically with regard to employment contracts, is force majeure a clause that is a tool that's really kind of available with employers at all?
So the answer is, generally speaking, no, because you would typically not find a force majeure clause in an employment contract, and you would typically find that in other types of contracts. So that's more in the context of employment contracts. But generally speaking, force majeure has obviously been interpreted by courts over the years to basically look at scenarios that the parties did not contemplate at the time of contracting, something which is impossible to perform. So essentially, if you look at the law on this, it's contained in Section 32 and Section 56 of the Contract Act. And to the extent it's part of the contract, it's covered by Section 32. And to the extent it's extraneous to the contract, where you're actually looking at impossibility of performance, you're looking at Section 56. But I don't want to get too much into the legalese, because I gather the audience is more business and non-lawyer. So therefore, I'd probably say that to be very specific to your question, it's a very challenging task to invoke force majeure successfully. And while in the last few weeks, the Delhi High Court and the Bombay High Court have come to the rescue of certain parties by giving them the benefit of force majeure, but those are more in the nature of interim orders for balancing equities. Those are not really, principles where you can say this COVID situation would qualify as a force majeure scenario, because force majeure is a very, very situation specific clause. A COVID may perfectly apply to a particular scenario which involves, let's say, going out and performing some activity which is constrained by vehicular movement or aircraft movement and things like that. May be completely inapplicable in a case where such travel or such constraints are not relevant. So that's one thing. And secondly, in the context of, for example, I don't want to. I'm presuming you'll go into the landlord issues and all that. But to the extent, these are temporary in nature, and there is a chance that it could be revived. You would still not get the benefit of force majeure. But I must say that everything will depend on what you say in the contract. So I don't know if that answers your question.
Got it. Okay. So when come to you, Aparajit, just staying on the theme of force majeure and the way it kind of applies to rental contracts. So what is the trend that you're seeing there? I mean, are lessees trying to invoke force majeure to be able to get out of their obligations or to renegotiate the rents that are currently owed to the landlords?
So carrying on from what Ramesh said, the construct is the same, which is Section 56 of the Contract Act, more so from a lease point of view, and also provisions of the Transfer of Property Act. Without getting into legalese, from a commercial standpoint, the underlying principle is that the property in question will have to be will stand destroyed or cannot be used for the benefit of the party, the lessee, and for which it was originally leased out. In a sense, the force majeure construct for leases stems from the fact that the property has to be destroyed so that the party cannot enjoy it. Technically speaking, what we have been advising clients and what we've generally been seeing is being understood by the industry per se is that this situation is not a force majeure from a lease and a property standpoint. While people are taking that recourse, people are asking for suspension of the term of the lease or asking for rental reduction. We are seeing that every day in the news. But legally speaking, for a force majeure to kick in from a property point of view, there has to be a destruction of the property to make it not utilizable by the lessee. So from that perspective, legally speaking, it's technically not a relief which is available from a lease standpoint.
Got it. Okay. Aaron, if I can come to you again, staying on the theme of force majeure, how do you kind of see it panning out on ability to execute both customer orders as well as to ensure that suppliers are able to kind of keep up with their side of the bargain? I mean, does it operate a little differently with customer and vendor contracts as opposed to how it does with rental and employment contracts?
So my view on this is slightly different, where in case of a customer contract, many of these contracts do not have force majeure clauses in them. But if you do, and if the clause does cover acts of God or acts of government, which would cover a lockdown, many of such clauses would not specifically talk about pandemic, but could cover a government order which stops a factory, then seeking some protection under the force majeure clause could come to a certain rescue, not to excuse you from performance, but maybe to win some more time for you to complete your delivery and complete performance once we're out of this lockdown. What is also very important to keep in mind is, while we're seeing a lot of discussion on force majeure, I think there is a realization that many of these disputes will not go to court, but businesses need some leverage to get across the renegotiating table. Most businesses want to relook at contracts and the commercials to deal with current challenges, to defer supply orders and timelines. And force majeure is being used as a tool to bring the other contracting party on a negotiating table. So even if the clause is not strictly applicable, we are seeing many businesses go ahead and issue a force majeure notice to seek to take advantage and benefit of the clause. and then followed by a period of negotiation. We are seeing courts being extremely sympathetic in terms of granting some protection and excuse to commitments which have been affected by this lockdown. And I think what we also need to keep in mind is time value of money. If there is a certain payment commitment, I think many businesses realize that if they were to lose a legal battle, maybe in a year or so, they may have to end up paying it with interest. But given the current situation, they do not want to pay it now. So even if a force majeure clause is not strictly legally applicable to you, I think many businesses continue to evaluate availing this for getting a commercial advantage, if not a legal victory.
Got it. Thank you, Aaron. So I think the takeaway that's kind of coming out of from all three of you seems to be that the strict legal application of the clause itself is fairly difficult to enforce. However, at a practical level, companies are utilizing this clause to be able to get hold of a commercial advantage. Right. So we can move to you, Harshita. Anything that you would like to add on force majeure itself?
Nothing in specific. I think I would resonate the thoughts that the co-panelists, shared on rents and contracts and supply contracts. I think just quickly to pick up, a question which came and could be just pertinent to answer that in this context, because we're speaking in the flow about some supplier contract where they can claim with respect to one supplier from a particular country where they can claim a force majeure for non-supplying. So just to quickly pick up that example, because we've also been dealing with one such situation where a startup in India was basically picking up manufactured products from a destination in Europe. Now the European supplier invoked force majeure for two reasons in the contract. One was for non-availability of workforce. Two was for the shipment costs have suddenly gone steep and they're pretty high, and so they cannot go ahead and send the materials. So what we have been advising our client is for the former, where the supplier is claiming a force majeure for non-availability of workforce, or picking up a position where the raw materials aren't available because of the lockdown applicable to those jurisdictions. It may be possible for the force majeure to be invoked. However, for the second one, which is with respect to the shipping costs being high or choosing one shipping supplier over the other, it will be difficult to say that force majeure really applies there, because it will be more of a commercial impediment than an act which is beyond your control. So be very careful when you're invoking the force majeure clauses, because there has to be something which is not anticipated and which cannot be controlled by you. If you do not have any reason which can fall in these two brackets, it will be difficult to say that you want to invoke a force majeure with respect to a supplier.
Got it. Thank you. Thanks for that, Harshita. So now moving on to the next strand of the conversation is really around employment contracts. So if I can start with you, Harshita. See, I think there is a clear intent on part of the government to say that, look, don't cut jobs, don't cut wages. Equally, companies on the ground are strapped for cash. And while I'm sure the intent is to be able to protect jobs and salaries, companies are also not very clear as to where they're going to find the cash to be able to protect the jobs. So at this point, we're also kind of a little bit, we're seeing conflicting notifications and slightly confusing circulars floating around. So are you able to tell us what is the current position? Is the intent of the government, is this like in the nature of a recommendation? Or is this like a law, that companies have to necessarily retain all employees and they cannot sack anyone? The second and follow-on question to this is, we heard that there is some kind of a circular that said that you can't let anybody go till the date of the first lockdown, which is about, say, 14th of April. Now, the fact that there has been an extension, does it automatically mean that the ability to possibly sever or terminate a contract, goes away till the time the lockdown continues? So, are you able to give us a sense of what is the legal position on this, please?
Sure. So I think to answer the first question, and I would take it from what Ramesh had mentioned earlier, while speaking, which is that there have been a lot of circulars which have been floating around and government advisories, which are not as clear as they're supposed to be in terms of these positions. So there is a little bit of ambiguity around it. However, to err on the on the safe side and on the side of caution, what we have been advising clients is, one, that a lot of these, it's more in the nature of a directive than just an advisory for some states. Clearly, like Telangana, for instance, I would pick up, because they have been coming up with regular advisories saying that salaries must be paid, there should be no job cuts, there should be no salary deductions, employees should be permitted to work from home, etc. So for those states, it's I would say it's more in the nature of a directive than an advisory. So, to work on a conservative basis, please do not deduct pays for the period of the lockdown. Just to tie it up with your second question, which is that whether it extends for the period beyond April 14th, I don't think there's a clear-cut answer, because none of the governments state governments, I mean, have been very clear in coming up with prompt directives, after the lockdown has been extended, in terms of, extending the directive or extending the advisory beyond April 14th. So I think a lot of these circulars have been dated end March or early April, which was only till, applicable till April 14th. Having said that, I think what we have been advising clients to go on and do it is, because if you do not cut salaries for this period of lockdown, whether it is applicable till 3rd May or 14th April, I mean, an extended period 3rd May, there may be other methods or alternate methods that you can try, which is, cut down on the variable pay, which if you can, you may cut down on the bonuses which may come through the year, and any other method, but not, in terms of terminating them at this point. However, I understand in terms of startups, when we are speaking, a lot of our clients have also come back to say that there have been situations where where it's becoming very difficult for them to pay, and deferring salary payments also, for that matter. Where we have said that if hard calls need to be taken in terms of termination, ensure that you're following the process laid down under your employment contract and in terms of the HR policies, as well as the law wherever it is applicable. Ensure as much as possible that you do not cutting jobs in this period. If you have to, that you're open to litigation tomorrow in terms of any inspection or any claim by the employees tomorrow. But so that's what we are doing largely in terms of advising on the employment side.
Got it. Thank you. Thank you, Harshita. So just a clarificatory question, and if I can pose that to you, Ramesh, considering that a large number of participants in this group are possibly kind of joining in from Mumbai, what is the position in the state of Maharashtra? I mean, is this in the nature of a directive, or is it in the nature of a recommendation? And also, if you can throw some light on whether its intent is to kind of cover employees below a certain salary threshold, or is it pretty much across the board, going across all levels?
Yeah, I think that's Venkat. That's a very good question. And in fact, when I see the group chat, I can see that a lot of them are raising questions that, well, it was okay for March, so maybe the first circular was fine, but people are now feeling the heat because it's getting extended. So I think there's one area where this consistency in terms of inconsistency is that who will this apply to? So, I mean, based on my conversation with other lawyer friends and all that, what I find is that actually there are two diametrically opposite positions being taken. There are some people who have taken the view that if you look at the Ministry of Home Affairs notification, the entire context is the migration of workers and the whole, the tragedy that may result in. And therefore, it was issued in that context. And if you see the beginning part of the notification, it talks about that. So to that extent, even though the words salary or employees may be loosely used, would this really apply to white collar workers? I think in the first part, law firms like ours have taken a more conservative view and said that don't upset the apple cart. Continue to pay the salaries, and given the vagueness of the language and the fact that one has to take a humanitarian approach. And we also found, in some cases, employees were posting, salary cuts on social media, and then we saw some notices that were getting issued in the case of, without naming a company, but a very large company received a notice recently from the conciliation officer for suggesting compulsory leave. So I think, so the advice has kind of moved from initially saying go ahead and pay to now saying that it's vague. We would suggest a consent-based approach where you can talk to the senior people and tell them that this is something that we need to agree on, and do a more consensus-based reduction as far as the white collar is concerned, and look at continue to pay full wages as far as the protected workmen are concerned. So that's the approach that's been taken. As far as Maharashtra is concerned, your specific question, I would say it's not direct. It's actually directory and not recommendatory. But then, when you read the whole gamut of things together, there's still ambiguity, and there are different positions being taken.
Got it. Thank you, Ramesh. One of the things, Aaron and Aprajit, I'm sure the audience is very kind of keen to know about is what are the practical solutions, right? So I think everybody gets it that there is a trade-off here between what the legal obligations are and what the practical realities are on the ground. And there's a good recognition that we are dealing with a soft issue. There is a humanitarian angle to this. So I'm sure the intent of most participants is to kind of soften the blow and to kind of minimize the impact on the people. But we're kind of hearing multiple things, right? One is about unpaid leave, people being asked to go on unpaid leave, or people are kind of being transferred from, say, an employment contract to a consulting contract. So if you look at the non-regulated category, if you may use the word, if you're not really kind of talking about workmen or blue-collar workers, but where the relationship is kind of governed by an employment contract between the company and the employee, is it permissible for the company to go back to the employees and request for an amendment in the contracts and with mutual consent agree as to what the revised terms will be, including people saying that, look, I'll pay you maybe 25%, 50% of the salary now, the rest could be deferred, or maybe it's a cut. So really two questions to both of you. One, what are the suite of solutions that is available? And B, in order to implement it, how does one go about doing it in a legal and a humanitarian manner? So we can start with you, Aaron, please.
Sure. So, I think based upon what we have been seeing, I think most employees have been extremely supportive of their organization, and salary cuts with a written consent of an employee, or a salary adjustment or deferment, converting a part of it to a variable pay if the market were to pick up during the later part of this financial year, is being implemented with the consent of an employee. And I think what's being done by many employers is to implement company-wide policies which go across the board with different layers, or maybe above a certain tier, or requesting employees to consent. That is being, in a way, supported by many employees, which is fantastic. The other interesting piece of advice which we have been doing is, while we speak about salary cuts, I think salary deferments may need to be treated differently. Many employment contracts do not specify the date on which a salary needs to be paid, because employment contracts are drafted by the employer. So they tend to be a bit vague in terms of when is the due date of payment of a salary. And many employers are considering possibly using that benefit or vagueness under an employment contract to pay some part of the employment salary upfront, of course, and a certain portion of it looking at a deferment for a reasonable period of time, not endlessly, but maybe a 60 or 90 days deferment. And as like the panelist said earlier, communication is highly important, and doing all of this in a way where you're communicating to the employee, but deferring a certain part of the salary. These are a couple of steps which we have been seeing.
Got it. Thank you. Aprajit?
See, clearly, as the speakers, panelists before me mentioned, the categorization is primarily blue collar and white collar. To look at it from the notification standpoint, 20th March was the Ministry of Labor advisory, just to sequence it out, which was an advisory in nature, followed by March 29th order being issued by the Ministry of Home Affairs. Now, interestingly, the 20th March Labor Ministry advisory referred only to workers and contract labor per se. However, the MHA notification, which came out on March 29th, actually spoke about employees also falling under the Shops and Establishments Act. Now, Shops and Establishment Act employees actually includes everybody, right? And thereafter, of course, we had a Supreme Court judgment on April 1st, which said that if the intent is that it is a direction in nature, then whether we call it an advisory or whatever we call it, it is binding. So I think carrying forward from that, and also the fact that MHA has issued the extension, I would like to just add a small point here. MHA has issued the extension of the lockdown order recently. And on 10th of April, they actually issued a consolidated order as well, consolidating all the notifications that have been issued over the last few weeks. So technically, in my view, the 29th of March notification, which dealt with employees' salary being paid, actually continues to be valid even after 14th of April, because the consolidated MHA notification has been extended by the Ministry of Home Affairs. That's number one. Number two, as my panelists have already said, as far as blue collar is concerned, which is the workman contract labor category of employees, I think the advice that we are giving is their salaries should definitely continue to be paid. As far as white collar is concerned, completely agree with Ramesh, which he mentioned. The consent-based approach is what we are also advising. Nothing stops us, an employer, from amending a contract mutually with the beneficiary under that contract. So a consent-based approach where people are evaluating deferred payout or variable component enhancement or other modifications to a contract, which is mutually agreed. So I think in a nutshell, blue collar is, I think it has to be paid. That's the position being taken. White collar can be addressed consent based.
Got it. Thank you. Thank you so much, Prajit. To quickly kind of share some perspective on what we see some of our clients doing. Clearly, there is a freeze at most companies on increments for the year. Variable and bonus awards of the last year have been frozen for most companies. There's obviously an employment freeze. With regard to employees, we are seeing slightly different treatment between contractors. I think most companies seem to have let go of contractors first before doing anything to their employees. Similarly, team members who are on probation, they seem to be treated differently as compared to those who are kind of confirmed and on rolls. So I think different companies have taken different treatments. I also see several questions. What is the appropriate percentage of pay deferment? Assuming mutual consent, etc. Honestly, no right answer to this. But we see a lot of funded founder-run companies where founders have gone down to 100% cut, anywhere between 25 to 100% cut. Most companies have taken a graded approach to say that people above a certain salary, so for the senior management, probably start at a 25, 30, 35% cut. Mid-management, possibly at about 50, 20%. And most companies that we talk to, we find that the people at the bottom of the pyramid, if it's say less than 50,000, 40,000, actually no pay cuts have been implemented. So the decision has been taken to just continue funding their salaries. Right? Obviously, what is the right approach is something that very clearly kind of depends on your particular circumstances. But to give you a quick snapshot of what we see as a trend in the market today. Moving on now to another subject, which is about cash flow recoveries. And how do you deal with customers who are not able to pay up, either genuinely because they have a cash flow problem arising out of COVID, or maybe they were in stress already, and now this is just an excuse not to pay up. So if I can come to you first, Harshita, considering that a lot of the participants here are really small to mid corporates who are heavily dependent on other corporates or the for their cash flows. If clients don't pay up, the fact that they are clients, and B, they are also larger corporates and who have got obviously great financial and legal muscle to kind of fight it out. What are the practical avenues that are available to make sure that we get paid on?
So, Venkat, I would actually like to pass on this question. I don't think I've dealt with these kind of questions, in terms of giving some solutions around especially during the COVID-19 situation. So I would pass it on to Aaron or Ramesh or Aprajit, whoever wants to take it up.
Thank you. Would one of you want to volunteer to answer that?
Just one thing, Venkat, I may just jump in, and probably it goes back to the earlier topic. One of the things that we are recommending when clients talk to landlords is to perhaps agree to some kind of an assurance that this concession that's being sought now will, one, be made good later if the situation changes, or to actually agree to stay on in the property for the entire duration of the contract, because one of the big concerns of the landlord is that you're going to exit at the first opportunity, and secondly that you will the moment you exit, I'm not going to be able to find a new tenant. So if there is any way in which you can address that concern and make it a win-win, that's something that we've been as part of the conversation that we are recommending that our clients have with their counterparts. But going to your question in terms of your own payments, vendors, and all that, I think one is, of course, I mean, everybody has to in terms of timelines take a hit. We are suggesting taking money in installments, offering upfront discounts, but obviously these are all commercial calls. Because to be honest, there is no commercially viable legal option, and courts are just and now with the monetary threshold for insolvency action increased to 1 crore, you're relegated to civil courts. So therefore, you don't really practically have any recovery option. So I don't know if that answers that question.
Yeah. So if I could come in. So for some of the startup clients we have, so in addition to the normal legal recourse, which as Ramesh correctly says, could be expensive and cumbersome, especially for a startup, a couple of other alternatives which could be considered is under the MSSME Act. There's the MSSME Samadhan portal where every startup who's registered under the Act can go and file an online complaint to the Facilitation Council. The Facilitation Council has 45 days to take a view on whether this is a complaint which they wish to act on or ignore, or leave it to the parties to resolve. If they act upon it, the Facilitation Council has powers to call for a conciliation, where they can issue summons to the opposite party as well to appear before it and try to arrive at a mediated solution. And because these claims are small, in my experience, there's been a larger number of successful mediations than I would have expected. So it has been successful in my experience. If the mediation is not successful, then the Facilitation Council has powers to act as an arbitrator or to refer the matter to arbitration. It is a fairly effective remedy which could be explored. It has already started in a small way, but I think a lot more can be done. A second option is a new Threads platform for where any MSSME who's registered can post a receivable for investors to come and buy it over to assign it. It works like a stock exchange where you can invest and acquire a receivable posted by an MSSME. I think that is something new which could get a lot more traction going forward, and it exists. The third action which we have been using and I find very effective is of course sending a legal notice, but copying that legal notice or sending a separate legal notice to the credit rating agencies who are concerned with a certain supplier or large corporate. I think faced with the current lockdown and environment, most corporates are looking at refinancing or additional borrowings, and their credit ratings are becoming more and more of key importance. So possibly addressing a letter to the credit rating agencies to put a legitimate claim on record and to bring it to their notice could bring a large corporate on the negotiating table fairly quickly.
Okay, very helpful. Thank you so much, Aaron. I think 3 very specific ideas for the participants to carry back. I just had a clarificatory question. I didn't quite get the thought behind the investors buying the receivables. So are you searching there's an exchange of that kind already in the country, Aaron?
Yes, there is an exchange of this kind, which has just started to my mind a couple of months ago. It is called Threads, Treds, which has just started. Of course, I can share the link as well. So there's not very high volumes on it, but it does exist.
Okay, thank you. Thank you so much, Aaron. Prajit, any additional thoughts to what Ramesh and Aaron have shared?
No, nothing on this point. I completely agree with Aaron and Ramesh, and I echo their views on this point.
Okay, perfect. Moving on now to the next theme, which is got to do a little bit with what's happening to term sheets given by investors. So if I can, What's the trend that you're seeing there? Term sheets that have already been signed where definitive documentation is not yet done, or cases where valuations and other terms are in advanced stage of negotiations. Are you seeing that the valuations are now being opened by investors, or is it a trend for them to kind of go ahead and go ahead with the documentation based on what has been committed in term sheets or verbal discussions?
So interestingly, actually, two things that we have seen in terms of the investments which are happening by third parties or investors. One is when they signed up the term sheet and they were in the documentation stage, where some of the investors are going ahead and signing up to documents, and obviously the second thing that we've been seeing is that certain term sheets are put on hold where the investors want an ability to renegotiate or think more on the valuation piece and get back to the companies or the promoters maybe after a couple of weeks. After they've sensed the waters here. Another interesting thing that we came across was one of the agreements definitive agreements which had been signed, and the promoters and the investors were actually working their process through to the closing. In the run up to the closing, one of the, it was a consortium of investors, and one of the investors have actually picked up a very interesting clause in the definitive documents, which we usually insert, and we believe it is harmless, and it goes with, and it's essentially claused up with very little or no negotiation sometimes, which is the Stancel Clause. So where the provisions of the agreement say that between the signing and the closing date, they should have been no event shall have occurred which could have which would have an effect on the which would materially or adversely impact the business or the operations of the company. So one of the investors in the consortium has actually picked up on that and said that because an event has occurred which is going to materially or adversely impact the business, may or may not today, but since it has the ability to, we want to renege from the contract. And we either, obviously, that the ability the investor is also, in terms of remedies, the investor has two things in hand in terms of the contracts. One is either to terminate the contract and walk away, and the other is to get the promoters on the table and renegotiate. So what we are advising there is that instead of terminating, it's just better to have the have the promoters talk to the investor as to what the renegotiated terms could be, whether it is only with respect to number, or it is the valuation number, or it is also with respect to rights. So that is an interesting development that we've been seeing, where where documents have been signed and the investor wants to renege. So I think as a recourse, I think two things are clearly available with the investors in that situation, and even in the prior situation where they signed up to term sheets, which is that you either renegotiate valuations, where I agree that the promoters, where we've seen promoters taking a hard stand in terms of not budging from the valuations, because for them also it's an unprecedented situation. They did not see this coming. So they don't want to, renegotiate the valuations because they don't believe the value of the business has gone down, or, probably. So that's one thing that we've been seeing.
Got it. Any additional comments? What I might do is, in the interest of time, possibly kind of move on with only one response from any one panelist on the questions going forward. Unless, of course, if you have anything to add to what the earlier panelists have said, we could probably take some quick comments. So, any comments there, Aparajit, Aaron, Ramesh?
Nothing from my end.
Nothing really. I think just a small one to add that the larger M&A transactions or the larger transactions are, I think, still moving at their original pace. It is the financial or the strategic investment transactions, as Harshita rightly said, where if it's at a term sheet stage, people are looking at a top-up diligence or trying to delay the process a bit to see kind of a wait and watch approach. We are all seeing it, but I think these are all unprecedented times, and we are all trying to evolve every day.
Got it. Okay. If we can now move on a little bit to the theme of what's going to happen when business begins to kind of limp towards normalcy, and we're already seeing, the partial lifting of the lockdown, etc. So one of the concerns we're hearing a lot from corporate is what happens in the event where the manufacturing operations or service operations are commenced, and one of your employees or contractors falls sick because of COVID, and he need not have contracted COVID in the course of employment, but for some reason, if he contracts it, if something really bad happens to him, what is the liability that the employer is exposed to in that situation? And given the fact that most companies don't have an option but to kind of get back to business as usual as soon as possible, are there any ways to really mitigate this? So maybe I'll start with you, Aaron, first on this point.
Sure. So I would straight away go to section 338 of the Indian Penal Code, which says that whoever causes grievous harm to any person by doing a rash or negligent act is liable to imprisonment up to 2 years and fines. So having a factory, having a place of work, and keeping it open, which results in a person being affected or in the spread of COVID-19, could attract a significant penalty under the Indian Penal Code. Of course, for the employer. I've come across certain FAQs issued by local district administrations, which say that an employer would be liable under the Factories Act as well, if any of his workers, contract the COVID-19 virus. And of course, there are powers under the Factories Act for the commissioners to come and shut down your factory and to force quarantine for yourself and all your workers. So I think the powers do exist under the law for the regulators to enforce and penalize. And I think, in case of a negligent act of keeping a place open in a way which can result in the spread of the COVID-19 virus does create exposure.
Okay, the question here really, Aaron, is the employer might not have anything to do with the employee contracting COVID. I mean, the employer is only kind of keeping the business open. Let's say it's a pharma company, or maybe it's a bread manufacturing unit, right? So it's obviously the permissions have been granted by the authorities to keep the establishment open. Now, in that situation, if somebody falls sick, it's not really it's not really kind of caused by the employer. But are you suggesting that despite not having been the cause, the fact that somebody has contracted COVID, the employer is still liable to prosecution? Is that what your point is?
Yes, because of the risk of spread of the virus. So even if he is not responsible for contracting it, because he kept it open and created a risk of it spreading to other workers, that's the risk I feel in it being possibly viewed by the regulators as a negligent act.
Got it. And this would be the case even if, at the time when I'm opening the establishment, I've got no clue that somebody is kind of maybe contracted the virus, right? I mean, if I know it, obviously I wouldn't open the establishment. So even if I did not have any prior knowledge about it, your point is that you could still be liable.
The question is whether it would be viewed, whether your act would be as extreme as it crosses threshold, or if it being viewed as negligent. Negligence is something which a prudent and a prudent businessman and responsible businessman would not do. So maybe if you're post the lockdown, you have enforced measures to control the spread of the virus, have only few people working in a secure environment, maybe not. But if it is viewed as multiple people packed in without any precautions, yes, to my mind, there is a risk.
Got it. So Aparajit, if I can come to you, what exactly is a liability? So let's say that I've taken adequate safeguard, right? And I've not been negligent. I'm following the rules. I'm not kind of running it at full capacity. Maybe 25% of the workers are coming in. I'm following social distancing norms inside the factory. I've provided everybody masks. I've given sanitizers. Yet something happens, right? And it's because of something that's happened outside my factory. And let's say somebody becomes really sick, or worst case, maybe there's a death. What kind of liabilities could potentially attach on an employer in situations like this?
So I think it's exactly what Aaron was saying, right? The exposure is the same. Aaron, if I can just take a minute of your time, I have a question. So on this, if the employer is following all the SOPs that have been provided under the Disaster Management Act, and then even if still an employee is sick and then spreads it to other employees on the floor, do you think there is some kind of an insulation that is possible? And I'm purely asking you from a litigation standpoint and a criminal law standpoint. I'm not a specialist at all on that. just for my knowledge, that following the SOP does help from a prudency point of view, just for everybody's benefit?
Yeah, I think in the current environment, I mean, one is the law, and two is the way the regulators and the courts are likely to react in the current time. We are currently living in a situation of paranoia. I mean, we have seen cases of people who are breaking quarantine, who are facing FIRs and imprisonment as well. So, and we're looking at regulators going after a big name to make an example. Of course, media cover and bad media publicity as well. So given the current paranoia which is currently being faced, I mean, there could be an extreme action and a view taken by the regulators, which may be arbitrary, heavy-handed, not with what we're currently used to, but it could be the norm given the current situation, and they could target you.
Right.
Got it.
So I think, Venkat, that itself answers the question that you posed on me. So I think there is a risk that we carry, no matter how prudent we are and how much we follow the SOP guidelines under the DM Act.
Yeah.
I think I just had to add a quick point here to Aprajit and Aaron. I think just that, while there is a risk and, we're living in a world where probably it will be very difficult to insulate us completely and 100% from what the law is and what the practice is on the ground. I think if an advice has to be given around that, I think the SOPs, etc., may be just followed, very strictly as an employer. That would, if not minimize if not eliminate the risk, would definitely serve as a very good defense tomorrow in front of the regulator. And if at all a legal claim comes against you, you can just tomorrow say that you've been following everything and this happened. So at least that can serve as a very good claim in a court of law tomorrow. So just don't get relaxed in terms of compliance with all these advisories, directives, state orders by municipal authorities also, particularly just follow them to the T in terms of compliances.
That's exactly my thought as well, Harshita. Thank you.
Yeah, I would, Venkat, if I may just add one line. See, one is the liability aspect of it, to what extent is, and I think everybody's already spoken on it. The other is, do you really want to take the risk of business interruption? Should there be a positive case, right? Because you're looking at your premises getting sealed, right? And so therefore I am expecting, as and when the lockdown is lifted, obviously there'll be an SOP, and people will obviously be asked to set apart workstations at a certain distance, and probably do thermal checks and all that. But I would expect responsible employers to actually even do better than that, and actually be more concerned about any potential business interruption apart from just liability issues.
Got it. No, I think on behalf of the participants, maybe Ramesh, my thought is, say we are all in between a rock and a hard place, right? At one level, business is already impacted. I mean, most companies are possibly between 0 to 20% of operations, so it can't really kind of get any worse from here. Now, on one hand, most companies are not getting paid by their customers, who are the larger companies. On the other hand, we are being told that, look, you can't sack anybody, you got to kind of pay things on time, etc. So the question is, what are the levers? So I'm sure I agree with you that no entrepreneur would want to kind of take a risk on commencing operations and again shutting it down. But it also looks to me like for a lot of people, staying where they are is not a great place to be either. So I don't know if there's any answer to that, which is actually going to be my next question, because some of the things that we are now kind of coming across, and it's an unfortunate question. A lot of entrepreneurs are now asking, look, I got two ways, and I'm talking about people who don't have recourse to either bank finance or private equity funding. The only option they have is to kind of dip into personal savings and keep things going. Are you kind of seeing a trend where people are now filing for liquidations? I know the trend towards bankruptcy is not as prevalent here in India as compared to maybe some other countries. But is that kind of changing in the COVID scenario, where owners are kind of coming forward and saying, to then kind of pump in more money into a black hole where I don't know when the company is not going to recover? Is it better for me to actually wind up the company? So would any of the panelists want to kind of take that question?
Maybe you can just, Venkat, I can just come in for for foreign companies that have operations in India, what we've seen is many of them looking at, we've been preparing memos on closure and how to wind up. So obviously, some of these decisions are not necessarily driven by Indian bottom lines or Indian business scenario or outlook, but we are seeing as part of a larger plan to look at cost cutting and anticipating financial issues. We've had a lot of inquiries and work starting on closure of Indian business. So that's unfortunate, but that's been our experience in the last 3 to 4 weeks, more in the last 2 weeks.
Okay.
If I could come in, I would agree with Ramesh. I mean, of course, we are seeing inquiries in terms of closure with Indian business, and it is unfortunate. Filings for voluntary bankruptcy is something which is being considered. If not now, I think people are looking at it as something they may have to take recourse to somewhere further down the road. What is being considered now is steps which can be taken by promoters to ring fence personal assets and mitigate their personal liabilities in case of a future bankruptcy. And various measures are being taken, such as documenting related party contracts, entering into employment contracts, making sure IP is protected in the relevant names. Of course, creation of trusts and other mechanisms as well. To ring fence personal liabilities, that is happening now itself because people are seeing a possible future bankruptcy as a risk.
Got it. Thank you, Aaron.
Venkat, if I come in, I think liquidation bankruptcy, not today. Today is definitely not the time when people are looking at moving in that direction. There have been relaxations by the RBI from the loan moratorium perspective. As you know, Bombay High Court has divulged into the NPA aspect as well. Thirdly, IBC has also been amended, as we know, and for it to come into play, the thresholds have been increased, timelines have been increased, etc. So I think in a nutshell, the government is trying to save it as much as possible, and more so the MSCV and the startup enterprises also more than the larger enterprises to reduce the financial stress. But I guess, as my panelists already said, perhaps down the line, but not today. Today, at least, people are trying to see how to ring fence their liabilities and stay afloat as much as possible.
Harshita, any comments on this topic from you?
No, I think just a small bit. I think adding to the government initiatives and maybe some could be helpful for some of the startups who've logged in today. There's another initiative for keeping you afloat, which is floated by the government in terms of the SIDBI initiative, the SIDBI working capital loans. That's an interest-free loan. Obviously, there's an eligibility criteria built in for who can apply and who will be able to get it, which itself is a little debatable to my mind because it's a little stringent. And would bracket out a lot of startups from the list. But yeah, that's again an interesting initiative, brought in by the government only to help startups during these difficult times. So I think just on that piece.
Thanks for bringing that up, Harshita. So, we're kind of beginning now to kind of touch a little bit on cash flow management and what avenues are available to raise funding. So we do have a couple of clients that we help to get funding from SIDBI. But you're right. I mean, the criteria is quite strict, and there are only certain types of businesses that are allowed to avail the funding. But we were quite surprised with the speed at which we were able to avail it. We were able to kind of satisfy the criteria. Then at least the mechanism seems to be working. I can see a few questions on cash flow management. So I'm going to take 2 minutes to kind of quickly provide an overview of what we are seeing. It's clearly a time for you to be sitting on cash. That's got to be the single biggest focus right now. So, between having a P&L view and a cash flow view, you should forget about your P&L for time being, just focus on your cash flow. So whatever is there in your balance sheet, you've got to find a way of converting it to cash, right? So if it is debtors, give discounts if required, follow up aggressively, talk to them sweetly, whatever it takes, but you've got to recover the money as soon as you can. Again, stocks, you may not be able to get your full value. Again, based on industry, you'll have to kind of take a call on when you see the thing recovery. But we are again kind of recommending to clients that they need to do what they need to do to be able to find ways to liquidate. creditors find ways to postpone the payment. Obviously, there's a prioritization that you need to do as to who are the critical vendors that you need to continue paying and who are the ones that you can afford to postpone. So find ways to squeeze some cash flow out of that. Now, these are all on the operation side. For companies that have got access to debt, if you've got a working capital limit from the bank that you haven't fully availed, it may be a good idea for you to try and avail that limit now and stay with the cash. We are seeing that a lot of banks currently, if you don't have a limit and you need to negotiate a limit, most banks are discussing. You may be able to kind of get the, but disbursements are not likely to happen till the time the lockdown is lifted, because there are legal agreements that you need to sign off on, and these need physical signature. If you're looking for a new loan, and if you got security and collateral to back it up, our recommendation is use the lockdown period to be able to negotiate those loans. But you have to probably wait for the lockdown to be lifted for the disbursement to actually happen. For those of us who have got venture capital funding, I'm sure that the investors are already in touch with you. If not, I think you need to have a very proactive conversation. Most companies we talk to are looking for a cash flow of anywhere between 6 to 18 months time, as a preparation to kind of see off the crisis. Yeah, so that's kind of a quick summary on the cash flow side. Some of you who are kind of supplying to larger companies may want to consider facility. Most large companies would have tie-ups with NBFCs or online lending platforms where interest rates are quite attractive, between 7 to 8%. So if you've got invoices against which you have already supplied goods or services, and there's a credit period that you do not want to wait for, then I think registering with one of these NBFCs or online platforms would be a good idea to get hold of some cash flow. Yeah, which moving on now and this is really open to all the panelists. One of the questions that we have from several participants is, when we kind of read in the media about what other governments are doing, right? So we are hearing about UK that is kind of putting about 85% of salaries into the employee's bank account. We are seeing US has come up with some mitigative measures for employees. Similar thing in Australia. So is there anything likely to happen? We have been kind of waiting for this entire stimulus 2.0, etc. The announcement doesn't seem to be kind of coming out. But are you kind of picking up any signals from your contacts in the government? What is it that we as MSMEs, as employers, what is it that we can now expect from the government maybe in the next 2 to 4 weeks time?
I think if I may pick on it, and maybe other panelists can follow. I think government, the central as well as the state government is also playing it by the day in terms of coming up with notification and regulations and how to deal with the situation and how to manage this and overcome the crisis. So I think it'll be difficult to predict what the government is likely to come. We have very recently been approached by the central government in terms of providing recommendations in terms of other laws, and where can the, measures be, what measures can be taken in terms of what we believe, what measures can be taken to help the economy stay afloat. So I think the government is taking that effort to connect with the audience, to connect with people, to take their feedback and see what best they can do. Would be difficult to predict what all they'll be able to do in the next 2-3 weeks in terms of the in terms of the objective solutions. But we certainly expect the government to do to take a very positive approach and come up with a good solution to this.
Okay, any thoughts on what that solution could be? I mean, is this going to be a direct transfer to employees' accounts, or is this going to be like maybe a partial waiver of loans that MSMEs have taken? I mean, what exactly is the thinking right now within government circles on this?
So I think for now, how I have been seen in and the point of reference that I was mentioning to you, where we've been approached by the central government, I think we have been asked to comment and take suggestions and feedback from the community at large and let the government know on what they are seeking for, and depending on that, they will analyze and see what they can grant. So I think that exercise of getting the feedback is on. We are already speaking to our client base and reaching out to the audience in terms of what they want the government to do. So hard to say what all can come up, but we are certainly providing a recommendation in terms of different laws, different compliances across the board.
Got it. Aprajit, Aaron, Ramesh, any additional thoughts?
One set of incentives which we have not seen yet, and to my mind could be expected, is possibly restructuring of stressed assets. So, and which we could include in interest waivers or write downs for various bank loans. So I think that has not been part of the earlier stimulus, and possibly some restructuring in that sense for a fresh start is something, to my mind, could be expected. Additional incentives from the Reserve Bank of India in terms of loans, borrowings, working capital expected as well. But in terms of operations, I mean, the notifications so far have been, I would say, pro-employee, and not in terms of the business. So there's not been too much on that front yet.
I think it's a complete, take it on an everyday basis, and government is of course trying to do whatever they can, and nothing further as such to add after what Harshit and Aaron have already said.
I would, I don't have, and I hope I'm wrong, but I am not really expecting any substantial money to hit the accounts of the MSMEs. So, but I think it's, I mean, one is of course just being flexible about all the compliances and perhaps some penalties and things like that. You know, a lot of the cost involved in running a business, if those can be reduced, you know, those will be, I think that will be great if we can look at whatever fees we're charging for setup of companies, for various, you know, various other purposes, processing costs for various licenses and all those things. If there's any way in which those can be reduced, because then you're also kind of incentivizing people to stay afloat and provide jobs. But in terms of hard cash, I'm not too optimistic.
Got it. That's a sobering response, Ramesh.
I mean, I hope I'm wrong. Yeah.
Fair enough. So one last question before we kind of move to closing comments, and this is specific to insurance policies. So, you know, some of us have also profit be able to claim any compensation from our underwriters in case we have got a loss of profit policy. I mean, this kind of COVID covered as one of the triggers because of which a loss of profit might happen.
So if I can take that and start the conversation on this point, whatever I have reviewed thus far over the last 5 odd weeks, insurance policies and giving advice, loss of profit or business disruption under a policy usually stems from a fact that there's destruction of property. Again, back to the similar force majeure kind of a situation. So if the plant is shut down because of an act of God, where it's an earthquake or a fire, or there's a destruction of the machinery leading to a disruption of business, then clearly there is a policy coverage. But a pandemic leading to a disruption of business is something that is not even contemplated in most of the global policies. No litigation, not that I'm aware of as yet, but there are already a lot of articles on the net and news around whether the policies would extend to cover a COVID-19 kind of a situation. But as of now, my view is that insurance wouldn't cover a pandemic situation leading to a disruption of business unless there is a destruction of property.
Got it. Thanks for that, Aparajit. Any additional comments on that, Ramesh, Aaron, Harshita?
Nothing from my side.
Nothing from my end as well.
Okay. I just saw one other comment from one of the participants, and this is again in the context of deferment of salaries. And maybe if I can come to you for this, Harshita, are you seeing within the venture capital invested companies where deferment is being offered to senior management in exchange for ESOPs? And if yes, I mean, typically in this kind of a situation, how does one go about valuation? In fact, I had this question even for companies that are kind of running out of cash, who are already VC invested, when they're now going back to their investors and saying they need to raise more money. I mean, are you finding some challenges on agreeing to valuations, etc., at a time like this?
So I think what we are doing and advising some of the investors on is that, and as a proposal in mind, I think what we are also doing is that apart from raising fresh capital, which isn't so easy, isn't coming easily, given the current market conditions, we are also having some investor buy-ins in terms of bridge rounds. where the flexibility the bridge round gives you is that you needn't have a valuation immediately available to you. You can peg it to the next round of value, next round whenever it happens. So say next round is happening in the next 18 to 24 months, you peg your conversion of the convertible instrument you're picking up in this bridge round to that that round, given the uncertainty around valuation right now. So I think, and the promoters are also getting some breathing space because they're getting some bit of a money from the existing investors itself. So that's something which promoters are exploring and can explore for the in terms of the audience here. They can explore talking to their investors and seeing if a bridge round can be available, a small bridge round to keep them afloat and deal with salary payments, etc. On your on your earlier question in terms of deferment of salaries and exchanging them with ESOPs, I don't think we've advised on exchange of ESOPs as a measure for sure. Deferment of salaries at the senior level and taking salary freezes for this for 2020 at the senior level is something we've been seeing.
Got it. Okay. Thank you for that, Harshita. I'm very conscious that we are kind of slowly winding down. I'm very glad that in retrospect we decided to allocate 90 minutes for this session and not the usual 60 minutes that we do. There was so many questions and a lot of very practical ideas. So I really want to thank all the 4 panelists that we have today. If I can quickly request you to maybe provide your closing comments, a quick summary, if you like, maybe not more than a minute each. Aaron, can I request you to go first, please?
Sure. So in terms of closing, I would like to possibly just touch upon a little bit of legal strategy, which I've been seeing. While many people have been speaking about force majeure, I think it's very important to evaluate whether you can force the opposite side to breach. Like I mentioned earlier, I mean, many people are looking at how to gain leverage to work on to rework and renegotiate a new contract. By forcing the breach on the other side, it may increase your leverage to in terms of renegotiating the contract and to rework the terms of the contract, because it is then your choice whether to accept the revised terms or the lower threshold proposed by the other side if he claims force majeure, for example, or to insist upon the original contract terms 100% or somewhere in between. So possibly being rushing to choose and trigger a force majeure may not be in your best interest at all times. A second very important point which I've been seeing is in terms of employee salary deferment or even a pay cut. Even if this has been done with the consent of an employee or in accordance with, I mean, your view of the law at that point of time, subsequent to that, if you actually ask the employee to work from home, you could be faced with the claim of an employee actually claiming salary, because he can say, I agreed to a pay cut on the basis of me not being required to work. Since I did work from home, you need to pay me for it. So when you do require an employee to agree to a pay cut, to a certain relaxation, getting him to acknowledge that he will be required to work for a certain amount of time, despite that, to my mind, is very important. So while there are, again, many different things to think about, many challenges, I think, I think many businesses will come out of this stronger, and yeah, happy to be part of this panel and support you on this. Thank you.
Thank you so much, Aaron. Prajit, would you like to go next?
Everything has more or less been spoken. Difficult and unprecedented times for all of us, and we are trying to grapple with the situation and be in compliance. I think being in strict compliance and following the orders and the directions is something that I would request everybody to follow. Disaster Management Act and its consequences are very strict penal consequences. They have overriding powers over other statutory provisions. And so, whether it be the salaries to workers, whether it be looking at deferment or renegotiating with employees, the white-collar employees, or insurance, or various aspects, manufacturing facilities, whatever it is. I think your advisors are all around, and just to ensure that everyone is staying safe and try to be in compliance in the direction and follow the directions of the government. I think that would be my advice. Thank you.
Thank you. Ramesh?
Yeah, I would probably say that it's very important to quickly end the uncertainty as far as this paying of the flexibility to manage your workforce and effect some pay cuts, because you are actually driving people to bankruptcy if you are going to defer this decision and force this cost on people across the board. So I think ending uncertainty is very important. I must just mention this. One of the clients mentioned to me, this was is a Noida-based client, and the district magistrate had called all the businessmen for a meeting, and apparently there was some kind of a vote on said, will you? The district magistrate asked, and probably in chaste Hindi, that किसी का पगार नहीं कटने का और सबको पे करना है. Then apparently about 80% of the people stood up and said, हमको जेल भेज दो, हम लोग पैसा नहीं हमारे पास. So I think that's the reality. So it's not going to be so easy to continue to insist that is paid fully. So I think that's not a fair bargain, and I think that needs to be addressed. And thank you for the opportunity, Venkat and TiE, for this. Yeah.
Thank you, Ramesh. Harshita, you have the privilege of having the last word.
Yeah, starting from it to the last one on this session. I think quickly two things. One is I think besides the fact that we are all in difficult times, and we've heard a lot about it, that the times are difficult, they're unprecedented, we're all in it together. I think it's time for all of you founders to take this as an opportunity to just step back, pause, and think about your business models. Analyze and take it as an opportunity. The businesses are changing, consumer patterns are changing in these times. So we may enter a whole new world after the lockdown is lifted. Take this time to understand where we are heading, and maybe it's time for you to think and pivot your businesses towards a different direction, and maybe that may be the mantra for success for all of you guys, if it has not been working so far. So that's about it from my end. Thank you, TiE, for the opportunity.
Okay, thank you so much, Harshita. So to quickly sum up, it's obviously been a great privilege and honor to moderate this very distinguished panel. I thought the standout for me was that this was not really a session filled with legalese and legal jargon. I think what we got was very practical commercial advice from all the four panelists. So thank you so much for simplifying this session for all of us, including me. Takeaway for me, and which probably all the four panelists talked about, is the solution to a lot of the challenges that we have is really good quality communication. Yeah, so constant engagement, frequent engagement with your employees, with your customers, with vendors, with government authorities you're dealing with is possibly the number one step that you need to take to make sure that you can control this problem. I just want to conclude by saying that, look, having attended several of these webinars and moderated a few, spoken in a few, I find that 95, possibly 99% of the stuff that is being discussed is it's a lot of negative energy, possibly a lot of pessimism floating around. But no, we should not forget the fact that we are not the business, right? I think as all of us as founders, entrepreneurs, we have an individual existence that goes beyond the enterprise that we run. And when all of us take a lot of ownership, we are very passionate. Probably work is 16 hours, 18 hours a day for all of us. Many of us refer to our companies as our babies. So there's a lot of emotion riding into this. But I think this is a good opportunity for us to remind ourselves that as a being, we are probably larger, more holistic than our businesses. So let's try and kind of keep a distance between the two so that we can take objective decisions on what we need to do with the business. Most importantly, take care of yourself. It's not just about staying safe physically from COVID. I think taking care of your mental health is a super important thing. Talk to people. I think forums like TiE are super important for that because they are a large support group, extremely responsive. So don't reach out for assistance. You will be amazed. As as Aaron said, that when he went back to the employees, he actually are willing to take pay cuts, right? So you will be amazed at what you could get only if you ask for it. So ask for help, take care of yourself. Yeah. Thank you once again, Naveen and team TiE Mumbai for this wonderful opportunity.
So thank you, Venkat. Thank you, everyone. This has been a great session. And rest assured, we'll be doing many more of such sessions with you all. And there was a great session saying that, there was a great suggestion saying that we should get you all back once the COVID lockdown is opened up, and then again have you all answer some questions so that we get more practical and realistic kind of answers coming. So thanks everyone. And for folks, these are the next webinars coming. Harshita is back tomorrow with us from 12 to 1, where she's going to be talking on key issues of looking at your term sheet during this time. And we're going to be doing a lighter one day after tomorrow evening itself with Chef Harpal Singh Soki, where he'll be talking about some of the interesting recipes that you guys can try at home during this lockdown situation. We have an Ask Me Anything with Anjali Bansal on Friday, and our signature retail association session on Sunday. So guys, stay safe. We'll be back with many more such things, and see you tomorrow, Harshita. And thank you everyone for all of it.
Thank you.
Thank you.
Bye-bye.
Thank you. Thank you.